Hey, it's Bernard Nomberg with the Nomberg Law Firm in Birmingham, Alabama. Wanted to take a few minutes to discuss some additional helpful tips that we think will help a claimant be successful at an administrative law hearing when they have appealed a denial of their attempt for Social Security disability benefits. And this comes into play, what we're about to talk about, it comes into play the day of and leading up to the hearing that you'll have in front of the administrative law judge, the ALJ. Now, in that hearing, which will last anywhere from 15 minutes to typically an hour at the most, in that room, in addition to the ALJ, the judge, myself or your representative, and you, will also be the VE, the vocational expert, and the judge's judicial assistant. So really that's about it. That's about 5 people who will be in the room. When you're in that room, be cordial, be polite, address people by their last names if you happen to address them. You will not necessarily talk with or to the VE or the JA, the judicial assistant. Typically it'll just be with your representative, the attorney, and the judge. And when you talk to the judge, call the judge Your Honor or Judge. Don't become too familiar. It's a place of recognition of the setting and the place where you are, and have respect for that. Of course you will. But don't be too comfortable. Be respectful of the time, and the court will notice that. Don't wear all of your Sunday best, so to speak. You don't have to dress to the nines. And by that I mean collared shirt, a nice dress, anything that is acceptable when you want to go to someone's home, like for dinner, but not so much that you're in a t-shirt or cutoffs or shorts. Nothing like that. Just be mindful of where you are in the forum and dress accordingly. But at the other end, you don't have to dress, nor should you dress with all your jewelry and a top hat and a cane and all of those things. Just dress naturally, dress comfortably for the event. If you have restrictions such as sitting or standing limitations, and you sit there or stand for the entire thing that go against what the doctors are telling you, the court will take notice of that. So if you need to stand, if you need to sit, if you need to move around, do so. You'll still be within earshot of the microphone, but be mindful you don't just have to sit there the entire time. If you need to have a list of your medicines on hand, bring those. If you need to have a list of your doctors, just so you'll have the list, bring things like that. This is not meant for you to read directly to the court. It's just as a reference material, if you will, so it'll aid you in your answering when the court has questions for you. As I said earlier, the vocational expert is not there to have discussions with you. They're there to aid the court because they will have looked at your case, looked at your work history, your education, etc., and they will give the answers to the judge's questions. And on the occasion, your representative, your lawyer, may have some questions for the VE as well. One of the biggest things, one of the hardest things to get across to a person who is applying for benefits, in our opinion, it's not your day to be full of pride. It's not your day to boast about all the things that you can do. But at the same time, it's not your day to grovel in how bad things are. And what do we mean by that is, if you're asked what are those things you can do, explain those things in as much detail as you can as to what you can still do. On the other hand, when you're asked, if you're asked, what can you no longer do, be able to explain those things as well. This will aid the judge. This will show credibility. This will help in your decision that the judge will eventually administer or issue in the upcoming weeks after your hearing. Lastly, there really is no sense of entitlement, even though that may be what they're called, but these benefits under the Social Security Administration, really you have to qualify to earn them and to be paid them. So your approach in that hearing should be the approach that you're not looking for a handout, that you really are trying to explain to the court that you really don't want to be there. You really would rather be back at the things that you normally do in life and having the normal life experiences and working and doing all of those productive things but you're here, and you're here because you have medical conditions that have brought you here that do not allow for you to have any reasonable or expected lawful employment. So those are kind of some more thoughts that we have. Hopefully you'll be successful at your hearing. Follow these tips and others that we have in the other videos. If you want to talk about it, just give us a call, 205-930-6900. Nomberglaw.com is our website. We have several videos that deal with Social Security benefit claims in this channel. So consider subscribing to it. If you like this video, give us a thumbs up and tell us why. And if you did, we'd like to hear that as well. Lastly, we can also be found on Facebook and Twitter.